The webinar is entitled COVID-19 Vaccine, What Can Employers Do? When we were discussing a few weeks ago what might be a topical subject, we had no idea how accurate a hit this would be for the 24th of February. It was as though Boris Johnson was promoting our webinar last night, because obviously this is a fast-moving situation and vaccines are very, very topical at the moment. The format today will be 3 presentations. My name is Chris Mayers. I'm the Head of Employment and Immigration in Wales. Andrea Thomas is also an employment partner in the team in Wales, and Ruth Sherritt is from our licensing and regulatory team. So Andrea will speak first on general issues. I will then speak more specifically on employment tribunal issues and the pitfalls that might apply in this situation. And then Ruth will be discussing it from the licensing, regulatory and health and safety perspective. It would hopefully be a very interesting webinar, because there are different perspectives depending on which particular area of law is applicable. Employment law is one jurisdiction, health and safety is another. So we're very grateful that Ruth is able to join us as well to give us that particular perspective. As I say, there'll be 3 brief presentations. We've already had lots of questions, thank you, submitted in advance, so we hope to leave about half an hour or so to deal with as many of the questions as possible. Please do use the chat functions if there's any questions that you'd like to raise that you haven't already done so. We will try to answer as many as we can during today's webinar, but if not, then we can hopefully get back to you if we've got contact details for you. All right. So without further ado, I'd like to introduce Andrea Thomas, who will deal with the first presentation.
Good morning, everybody. Could I have the first, good afternoon even. Could I have the first slide, please? Thank you, Amelia. Right, I'm going to look at what employers can do to prepare for the issues they may encounter with a vaccine rollout. Now, first of all, why is this such a concern for employers? Well, first and foremost, most employers will care about the well-being and the health of their workforce, and also the other people they come into contact with. Employers also have a statutory duty to reduce workplace risks, both to their own staff and other people who are affected by their workplace activities. And that's something Ruth is going to look at later on in the seminar. This area is going to be of particular concern to those people working with vulnerable groups, notably within the care sector, but possibly other groups such as health, or parts of the education sector. The efficacy of the vaccine is such that even those people who have been vaccinated remain at some risk, for example, elderly people. And of course, there are some vulnerable groups, such as younger people with learning disabilities, who don't yet have access to the vaccine. There's also growing evidence that having the vaccine helps reduce the risk of transmission. So it's hoped that ensuring that the whole workforce is vaccinated will help create a safer workplace, both for employees and those people they come into contact with. So there are good reasons for employers to want to ensure that their workforce is vaccinated. But on the other side, you have competing rights for employees who may not want to be vaccinated, who may think, well, it's not a statutory requirement for me to be vaccinated, so why should you be able to force me? So you have this tension between the competing rights. And as the rollout progresses, in fact, employers may come under more pressure. As more and more people are vaccinated, people may become more disinclined to come into contact with others who have not been vaccinated. So perhaps they won't want to allow them into their homes. They won't want close contact services from people who have not been vaccinated, for example. And also, we're increasingly hearing about clients who are insisting that their whole supply chain is vaccinated. So in fact, employers may also come under pressure from their own clients to ensure that their workforce is vaccinated. Could I have the next slide, please? So what can employers do to prepare for all the issues? Now, first of all, it's important to make sure that you do have your risk assessments in place and that they're also updated to take into account the fact that the vaccine is now available, but also to take into account what other alternative measures you can take for people who won't or can't be vaccinated. And that's something Ruth is going to look at. It's also advisable to have a vaccine policy in place if you want your employees to be vaccinated, and that is where you set out what your stance is and your reason behind that, why you are so keen for everybody to be vaccinated. For example, because you want to protect your workforce, those people you come into contact with, and also that you want to maximise the number of people you can safely have in the workforce. You should also think about data protection. If you're holding information on whether people have been vaccinated, then that is likely to be special category data under the GDPR and the Data Protection Act 2018. So you need to identify a lawful basis and also an Article 9(2) condition for processing special category data. Now, you are going to be able to do that in most cases, but it's important you look at your documentation and you update things like your privacy notice, your data protection policy, and your retention policies to take into account the fact that you're processing this kind of data. You are going to need to think about those people who can't have the vaccine. For example, people outside the care and health sectors who are currently too young, people who may have medical conditions such as severe allergies, or people who are pregnant and may not be able to have a vaccine or are not advised to have the vaccine at present. So you're going to need to ensure that you think about alternative measures to protect those people, and also that you ensure that you don't inadvertently discriminate against those people through your policies. And last but not least, you're going to have to look at those employees who are hesitant and disinclined to have the vaccine, and that can be for a number of reasons. The main one is actually likely to be misinformation and fear. As we all know, there is a huge amount of fear and misinformation out there about the vaccine. That is, we think, affecting take-up. For example, Matt Hancock said a few weeks ago that only 2/3 of people working in the care sector in England are thought to have had the vaccine. There may be people with religious reasons or philosophical beliefs who think that they cannot have the vaccine. Now, in most of these cases, you will be able to overcome their fears because they're actually based on misinformation. So it's important to have a program of engagement with employees and to look at perhaps having literature available to make sure that they have the right information, and perhaps even having a health professional in to talk about them. Now, most religious groups do endorse a vaccine, and it's suitable for vegans. So a lot of those fears you may be able to overcome. Now, there may be a small number of people who have genuine religious or philosophical reasons as to why they don't want the vaccine. And it's possible that some of those people will be protected by the Equality Act, but Chris is going to look at that in more detail as part of his presentation. Could I have the next slide, please? So what if employees still refuse? Well, in the UK, the vaccine is not mandatory, which means that neither the government or employers currently can force people to actually have it. Whether you can introduce it as a condition of employment is a separate issue which we'll look at. But could this basic position change? It is possible. It's being reported in some places that the government are thinking about whether they may need to make it mandatory in some sectors, for example, care, but that is just speculation at the moment. The official government line is that no, it's not going to be made mandatory, and several ministers have said that it may be discriminatory, in inverted commas, to make it mandatory, although they haven't explained what that means. If they were to make it mandatory, they would have to amend existing legislation, such as Public Health Control of Disease Act 1984, and they would need to do that probably through primary legislation. If they did do that, I anticipate that it's almost inevitable that they would face human rights challenges. So as an employer, whether you are going to take further action, for example, by introducing a mandatory vaccination policy, is really going to depend on your own individual circumstances and to what extent it really is a big employer problem for you as an employer. So that is likely to be governed by the number of people involved and the sectors you work in. So it may be a big problem for you, perhaps if you work in the care sector. It's less likely to be a problem if, for example, you're a firm of accountants or lawyers even. You will also need to look very carefully at what alternatives are available to protect staff without going down that route. So, for example, can some people stay working at home, or can they even change roles so that they can work at home? Can they be adequately protected through PPE or social distancing measures? So as part of that process, you need to look carefully at your risk assessment and really make sure that you document your decision-making process and why this is such a concern for you. Because if you do take further action, that will inform an important part of your justification. Next slide, please. So what can you do in terms of making it mandatory? Can you introduce it as a condition of employment? Yes, probably for new employees, but you need to be careful to avoid a blanket policy because that may discriminate against some employees who can't have it. Also be careful not to ask questions which are hard questions prior to employment. That may be discriminatory. Existing employees are more difficult. There are two schools of thought. The first one is just to introduce a mandatory vaccination policy and to say that if employees refuse, then they are refusing a reasonable management request. The difficulty there is what you can do if employees still refuse. I think personally that it would be difficult for you to take disciplinary action in circumstances where it's not mandatory under UK law, and in most cases you won't have a contractual requirement. The second option is, can you amend existing contracts to include a vaccination clause? That is possible, but normally that requires consent, and if employees don't want the vaccine, they're not likely to consent. In those circumstances, you're probably looking at dismissal and re-engagement. That carries the risk of unfair dismissal claims for employees that have more than 2 years service. You may be able to establish an SOSR reason, some other substantial reason in some cases, but that is going to very much depend on your circumstances and the difficulties you face as a business. So unfortunately, there's no universal guidance on this. It will have to be looked at on a case-by-case basis. You can envisage perhaps in sectors such as care where that may be possible, but it certainly carries a significant risk. And that is something Chris is going to look at in the next part of the presentation. Chris.
Thank you, Andrea. Right, can we have the next slide, please, then, Amelia? Okay, what I'm going to do is I'm going to look at the potential claims that we anticipate might arise out of any dispute in relation to whether or not an employee should be vaccinated or not. For those of you familiar with employment law, there are, under the Employment Rights Act of 1996, 5 potentially fair reasons for dismissing somebody. The 2 that we're going to have a look at here is conduct or misconduct and SOSR. SOSR is some other substantial reason. So under the Act, employers have a discretion to try and justify dismissing somebody on the grounds of some other substantial reason. And I normally refer to that as the sweeping up provision, because it doesn't come with one of the previous four. So is there some other substantial reason, something unforeseen, unprecedented, that might justify an employer in terminating somebody's contract of employment? And here we're in unprecedented times with the global pandemic. So SOSR, I think, is going to be of particular relevance. In relation to the general question of misconduct, there, of course, is a well-trodden path that employers can dismiss employees for misconduct. And usually that's categorized as a failure to follow a reasonable management instruction. But the difficulty is, what is reasonable in this context? Because clearly, if you say to somebody, you must not use that milling machine over there because the safety guards have been taken off it and it's being repaired, and they go ahead and do it, that's very straightforward. Here, though, there are much more nuanced areas. And as I've indicated there, one of the things you'd have to do is consider the nature of the business, the employer concerned. Care home providers clearly have to provide care to people, whether it's actually in their nursing home or whether it's domiciliary care. That's completely unlike accountants or lawyers, where much of what they do can be done remotely, can be done from home, and doesn't involve close client contact. As well as being a potentially fair reason, it must also be procedurally fair. And those of you who deal with employment know what that means. You have to have an investigation, you have to have a disciplinary hearing, and you have to give the employee the right of an appeal. And they're entitled to be accompanied by a willing work companion or trade union representative. Currently, it's untested whether a requirement from an employer that an employee should be vaccinated would be a reasonable management instruction. I confidently predict there's going to be a lot of test cases on this point, and we've already seen some of them already. As Andrea said, very clearly, you need to have an audit trail. If you're going to take a decision to dismiss somebody because of their refusal to be vaccinated, you need to demonstrate why. You need to show that you'd adopted an appropriate policy, that alternatives were considered to dismissal, as such as working from home, PPE, changing the role of the person involved, etc. And as Andrea said, and as Ruth is going to say, a lot of this is to do with engagement with employees. It's all about encouraging and educating people to understand the benefits of the vaccination. Final bullet point there, constructive dismissal. Again, for those of you who deal with employment issues, you'll know that in certain circumstances, an employee can resign and claim it's as though they've been dismissed, which is why it's called constructive dismissal. In order for an employee to succeed with a constructive dismissal claim, they have to show that they have resigned in response to a breach of a fundamental term. And it remains to be seen whether, if a employee resigns claiming that they were being forced to have a vaccination by an employer, whether that would amount to a fundamental term. Right? Can we have the next slide, please, Amelia? You also have to have a weather eye open for discrimination claims, because the whole raft of anti-discrimination legislation will apply in all employment circumstances. It's all consolidated in the Equality Act 2010. The most obvious one we need to mention today is in relation to disability. As Andrea's already said, there are some employees who would not be expected to have the vaccine. Even this morning, there was debate on breakfast news as to what is the situation in relation to pregnant women. And I think, to paraphrase, the jury's out on that at the moment. But you have to be clear that whatever decisions you make, whatever policies you apply, they apply equally without risk of discriminating against people on the grounds of their protected characteristic. So as I say, the obvious one is disability, but it would also include age. So you have to, again, if somebody might be considered as disabled within the meaning of the Equality Act, you have to consider what reasonable adjustments you as an employer must make. There is a legal requirement on you to make reasonable adjustments if somebody is disabled within the meaning of the Act. And there's also the penultimate bullet point there, that you can be liable if you discriminate against people by association. So, for example, if you have an employee who is living at home with an elderly relative or disabled relative who's shielding, you've got to be careful that whatever steps you take in relation to your employee does not result in a disability by association discrimination claim. Amelia, can I have the next slide, please? Okay. Again, protected characteristics under the Equality Act: race, religious or philosophical belief. We all know that in relation to race, there's been a much lower take-up in the BAME groups. That, again, is just a matter of education and encouragement at the moment. Religious beliefs, you can't discriminate against employees on the grounds of their religious beliefs. But as Andrea has already mentioned, the vaccine is in fact endorsed by most religious groups. The UK Sikh Council, the British Board of Deputies of Jews, and the Muslim Council have all come out and said they have absolutely no problem with their adherence to those faiths being vaccinated, and they're encouraged to do so. An interesting point, again, you can't discriminate against people on the basis of their philosophical beliefs. That is an interesting one. Some of you will have seen there was a case last year involving a vegan who it was found by an employment tribunal that amounted to a philosophical belief, which prevented him from being discriminated against by his employer, the League Against Cruel Sports. The final point on there is that if you are subject to a discrimination claim, it's always worth bearing in mind the justification defense in relation to certain claims of discrimination, particularly indirect discrimination. The employer can rely on the defense of justification if they can show it's a proportionate means of achieving a legitimate aim. And of course, helping to combat a global pandemic might well fit into that. Right? Next slide, please. Other risks, there's here what I would call the nuclear option. Contracts of employment, of course, are a matter of negotiation. If you offer somebody employment, you offer to employ them for a particular remuneration subject to particular terms and conditions, and they decide whether or not they want to accept it. The difficulty is if you want to subsequently impose a unilateral change of contract. If the employee agrees, well, that's fine. But if they don't agree, in certain circumstances, you can actually fire them and then offer to rehire them on the amended terms. We saw quite a bit of this last year because some employers who didn't wish to furlough employees decided that what they would do is they would ask the workforce to agree to a reduction in salary. And if they didn't agree, they were then fired and then immediately rehired, but at the lower salary. So what that means is the claim by the employee then would only be for the differential between what they were on and then what they're on under the new contract. It's a risky business. Certainly you would need to take legal advice if you're thinking of doing that. It's equivalent in some ways to redundancy. And if you get it wrong, not only do you pay the normal compensation, but you end up having to pay a protective award of up to 90 days pay per employee that you've done it to. And if there's collective consultation required, which there would be in that stage, if there are 20 more employees, you have to go through the collective consultant requirements and you must notify the Secretary of State of what you're doing. I've just mentioned there as a last point for consideration that Article 8 of the Human Rights Act does guarantee a right to respect for private life and a ban on physical and psychological interference. So we're bound to see some employees reaching for Article 8 of the Human Rights Act to justify not having the vaccine. Thank you. Can we now please have Ruth?
Thank you, Chris. Health and safety, for years, everybody has groaned when everyone says health and safety. It's just red tape, it stops us doing our job. But bring a pandemic into the mix and suddenly everybody's interested. There's lots of political views about the health and safety aspects of the pandemic, so I'll try and be as neutral as I possibly can. Firstly, health and safety 101. As an employer, you must protect people from harm. You have to eliminate or reduce as far as possible the risks to health and safety. That's what health and safety lawyers like me call the safety duty. If you break that safety duty, you commit a crime. If a company breaks the duty, then it gets fined. If a director is directly involved in that breach of duty, then the director also commits a crime, can get fined, can even get sent to prison. Employees also have a safety duty to take reasonable care for their own safety and those of others. and break that duty, and the employee breaks the crime. And we, health and safety lawyers, we talk about the creation of risk as being the offence. You don't need anybody to be injured to be prosecuted under health and safety law. Now that I've frightened you all witless with talks of crime and offences and being sent to prison, I'll calm you all down. All these duties stem from the Health and Safety at Work Act 1974. Now that act created the Health and Safety Executive. The Health and Safety Executive and various local authorities prosecute these offences. In the health and care setting, it's dealt with by the CQC. Now, the Health and Safety Executive has issued guidance in the pandemic. So if I can have the next slide, please, Amelia. I beg your pardon, the next slide after that, Amelia. Much of this guidance follows the public health guidance issued by the governments throughout the UK. So in terms of making your work and your workplace COVID secure, these are the key points that you need to follow. Risk assessment, that's the risk assessment Andrea mentioned earlier. Social distancing, cleaning, hygiene, hand washing, ventilation and air conditioning, talking to your workers and providing information. Just as a general industrial relations thing, that's a good idea. Working from home, following the government guidance, and taking care of vulnerable workers. Now, practical and legal point here. If the Health and Safety Executive says you have to do it, like the Nike advert, just do it. Health and safety guidance is treated in court like the gold standard of health and safety practice. If you discharge that level of, pay that level of attention to detail, then you'll be fine should you be prosecuted. Bear in mind, employees need to do all these things to be COVID secure in the eyes of the Health and Safety Executive, to provide a secure workplace and discharge their safety duty. So it all starts with a risk assessment. If I can have the next slide, please, Amelia. All employers should be risk assessing all aspects of their work. Now, this means that you start sitting down and you think about the risk presented by your work. If you employ less than 5 employees, you don't have to write it down, but frankly, if you're going to the bother of doing a risk assessment, then you might as well write it down and record it because it could be useful evidence later. I'm sure you've all done a risk assessment because for the first time ever, risk assessments have reached the mainstream media, but these points are what your risk assessment should cover. You need to identify what work activity or situations might cause the transmission of the virus. Think about who could be at risk, decide how likely it is that somebody could be exposed, act to remove the activity or situation, and if that isn't possible, control the risk. It's that hierarchy of risk that health and safety consultants and health and safety lawyers talk about, reduce and eliminate in the reverse order, do something different to avoid the risk altogether. And if you can't, because your work needs it, then reduce the risk by putting in other measures. So, for example, you could put in social distancing, you could stagger shifts, provide additional hand washing, cleaning facilities, and so on. That first point is important. It's up to you, the employer, to identify what work is done in your company or outfit and consider what activity might cause the transmission of the virus. So no one size fits all. As Andrea said earlier, the risk assessment for my law firm is going to be different to the risk assessment in a manufacturing facility, which is just different again to the risk assessment for a company providing care workers to go into individuals' homes. Again, your duty is to reduce the risk from your work as far as practicable. Health and safety law does not require you as employers to rid the world of the virus. Against that backdrop, if you get your risk assessment right, you make life so much easier for yourself and for your workers. It's that risk assessment that will help you see whether you need to consider vaccinations at all as part of your strategy to eliminate the risk of workers transmitting virus within your workspace. So my general advice is to work through those 4 steps, sit down and really think about it, and then implement the strategies that, for example, Public Health Wales are recommending: social distancing, cleaning, hygiene, hand washing, ventilation, air conditioning. So put the vaccines and the question of whether you're going to insist on your workforce having the vaccines into that context. If I could have the next slide, please, Amelia. When you think about whether you need your staff to be vaccinated, I would encourage you to have a think about these issues. Why do you want your staff to be vaccinated? If you're thinking that you need to do this to protect your own staff member who is to be vaccinated, then the health and safety law does not require you to do that. It's not your place to make that decision. Your staff members, with the exception of vulnerable adults, are capable of making that decision themselves. If you're thinking that you need to insist on vaccination to protect others who may come into contact with staff members who are not vaccinated, then you need to consider the evidence on the effect of the vaccine on transmissibility. We're at a very, very early stage on that. As far as I can see, there's only 2 studies that have been issued on transmissibility, and one of those isn't even peer-reviewed. One comes from Israel, one comes from the AstraZeneca people. In Nature, a couple of days ago, they were talking about how it's very difficult to find this evidence out at all because of the nature of the vaccine and the nature of the pandemic. It's worldwide, there are other measures in play. Who knows at this moment what the effect of the vaccine is on transmissibility. So what evidence you have on the presence of an unvaccinated member of staff within your workplace, have a think about how that impacts on the risk in your workplace. Bear in mind that you're putting in all those other measures to reduce the risk of transmission, hands, face, space, and so forth. You might want to take evidence, try and get expert evidence from a public health expert. Frankly, they'll all be a bit busy at the moment. But bear in mind the courts are going to recognise this, should it ever end up in court. Are you fearing that you're going to be prosecuted if you have a member of staff who is unvaccinated next to a member of staff who is vaccinated? Well, bear in mind that a health and safety prosecutor has to prove beyond all reasonable doubt that your failure to insist on vaccination is a breach of the safety duty, i.e. a material increase in the risk to health and safety. Again, we have limited evidence on that. If you're fearing being sued, not strictly a health and safety criminal law point, it's a civil law claim for compensation, but a claimant has to prove that they caught the virus as a result of your failure to insist that somebody else is vaccinated. Well, it's very difficult for a claimant to prove that they caught the virus at work, never mind that they caught it as a result of somebody else not being vaccinated. How can they prove they caught it from one other person? These are the sorts of things that the courts are going to be interested in should this thing end up in court. So let's say in the extreme you did have the evidence that you felt could justify demanding your staff to be vaccinated. Well, as Andrea said earlier, it's not mandatory. The government says it isn't going to be mandatory, and I would struggle myself to see how they could ever make it mandatory in this country. We have a very strong libertarian aspect to our laws, and it'll be a big push to get this to be mandatory. Say, for example, you insisted on a worker being vaccinated against their will. How would that actually work out in practice? You'd send them off to a doctor, they'd turn up and say, I don't want to be vaccinated. The doctor could not vaccinate them. The simple old-fashioned common law of assault by battery would stop them. You can't insist that your workers be vaccinated to that extent. So if you think that your staff needs to be vaccinated and then a member of staff refuses, then you've got to do the balancing act. What is your safety duty? What is the evidence you've got that vaccination will help? And then the rights of your workers. All I can say in terms of reassurance is that unlike the media, the courts will consider all the evidence. They're not interested in clickbait headlines. Health and safety prosecutions are incredibly complex. They're very fact sensitive, and the courts go through everything with a fine-tooth comb. If that gives you any reassurance that health and safety prosecution would be extremely difficult to mount, and it would be very difficult to prove. Thanks, that's all I've got.
Sorry, thank you very much, Ruth. Thank you very much, Andrea. I hope that's been helpful for everybody. And now we'll have an opportunity to answer the questions that we've received. Please do put questions in the box at the bottom of the screen. If you'd like us to answer them now, we'll try and answer as many as we possibly can. First question in no particular order then. As an employer, are you able to ask the question as to whether or not someone has had the vaccine? That obviously involves considerations of data protection. So Andrea, I think you're the obvious candidate for that one.
Yes, thank you, Chris. Can you ask the question? I think in most cases you're entitled to ask the question. The exception to that would be during the recruitment process. You can't generally ask pre-employment health questions. So you have to be careful around that. But assuming you're talking about your existing employees, you can ask the question. What you can't do, I don't think, is to compel them to give you the answer. The answer to the question would involve them disclosing health information to some extent, and generally an employer, with some exceptions, can't compel an employee to disclose that information. But as an employer, if they won't tell you, you are entitled to proceed accordingly and probably to assume that they haven't been vaccinated. As I mentioned during my presentation, if you do actually have that information on whether or not somebody has been vaccinated, you need to be careful how you store that, because that will be special category data, which is subject to further protections.
The next question is, how would you cope if staff who are vaccinated are not happy working with someone in the team who isn't going to be vaccinated? It's a very good question, and I think this might display a slight difference of approach or emphasis between Andrew and I as employment lawyers and Ruth as a regulatory lawyer, because my view as an employment lawyer is, as Andrea and I have both said, you need to be very clear what reasonable steps you can take, what alternatives you can consider. So the obvious point to make there is you'd have to consider as an employer whether there is a way in which their role or their team or their base or their location could be changed to avoid that particular problem. I do appreciate that doing that might simply just move the problem somewhere else. But fundamentally, it's again about encouraging people and educating people as to the benefits of vaccination, not only for themselves, but also for their family, their friends, and work colleagues. I don't know if you've got a slightly different perspective on that, Ruth, from the health and safety angle.
To be honest, I think it's more of an employment angle, how you manage individual employees within the workplace. I don't see that turning into a prosecutory point at all, really.
Good, good. Well, hopefully that's a relief for the questioner. Okay. Next question, which I think maybe for Andrea. What would be the course of action if an employee is required to travel abroad as part of their job, but they don't want to have the vaccine, especially if airlines in other countries adopt a no entry policy for people who are not vaccinated?
That is potentially quite a difficult issue. If it is a requirement of somebody's job for them to travel, and the fact that they are actually unable to travel because of the fact that they won't have the vaccine, then potentially that would mean that they're unable to do their job. I don't think that issue is likely to arise for some time because, you know, at the moment, not a great deal of travel is permitted, but certainly could arise in the future. I think in those circumstances, you would have to look at whether they could in some way do their job without doing the travel aspect. Could they perhaps do a slightly different role for you? If the answer to that would be no, then I think ultimately that may result in a situation where you might have to look at dismissing them because they are unable to do the role they're actually employed to do. Obviously, you would need to get legal advice around that, and you'd have to look at all the circumstances. Potentially, I can see that amounting possibly to an SOSR reason for dismissal. Would you agree, Chris?
Well, I would agree with that. I was going to say exactly the same thing. I think that is exactly what some other substantial reason SOSR was invented for. The sort of problems, conundrums that employers can't necessarily anticipate. But means, well, if we cannot use that particular employee to perform the role that they are required to do, can we then justify dismissing them? I think there'd be a good argument there. And the other thing, Andrea, I think is, arguably it would be redundancy, because if they're employed for a particular role, which they are unwilling or unable to fulfill, then it may be that they can be fairly made redundant. So hopefully that answers that question. The next one is specifically addressed to you. Am I understanding correctly then that a care home insisting on employee vaccination to protect other staff and residents is not necessarily going to help with transmission?
I think at the moment the evidence is fairly scant, as I said. I really can't see, and I've kept quite a close eye on the COVID evidence. I haven't seen much in the way of evidence on the effect on transmissibility. Robert Jenrick said something a couple of weeks ago. As I said, the Israel study is very limited. The AstraZeneca thing is very, very new. At the moment, the great joy is that the vaccine seems to work on the individual to basically reduce the effects of COVID if they do get it and keep them out of hospital. I mean, that's the great success of the vaccine so far. And as I say, the evidence on transmission is extremely limited at the moment. Hopefully, it will work and it will be shown, but vaccines generally are not there to reduce transmissibility. They're there to stop you getting a really bad dose and being really ill with the subject. You can't, even if you're vaccinated, you might still get something. You might still get the virus, you might still get measles, you might still get chickenpox, whatever. So in terms of a care home insisting on an employee vaccination to protect other staff, then I think the care home needs to think about what is the evidence, why are they saying that? And then again, we come down to insisting on employees having a medical, it is effectively you're asking your employees to undergo a medical procedure. There may be a soft way around this, in terms of, encouraging employees for professional ethics. Do you really want to be treating vulnerable adults in your care with the risk of, however minimal it might be? But in terms of regulatory prosecutions, as I say, the evidence is going to be the key, and it may come forth, but at the moment it's fairly limited.
Yeah. There's two questions in one here, I think, really. One of them I think we've skirted around in our presentations. Is there likely to be a difference in approach dependent on the industry sectors, care home workers as against office workers, for example? And is there more justification to make the vaccine mandatory in social care? Well, leaving aside the political and moral dimensions of that, would you like to answer that, Andrea?
Yes, certainly. Yes, I think certainly in terms of sector, it's going to be very difficult to justify a mandatory policy if you just work in an office environment. As you mentioned, I suppose as you mentioned it in part of your presentations, if you work in the care sector, I think you are more likely to be able to justify it. Again, you are going to have to look at it on a case-by-case basis. Completely take on board what Ruth says about transmissibility, etc. But it is possible that in that sector you will come under pressure from other sources. For example, families may start insisting that they only want people who have been vaccinated caring for their loved ones. People may only want people who have been vaccinated coming into their homes. So what the evidence is on one hand and what the pressures are on the employer won't necessarily always be the same thing. And from an employment angle, I think both things could be relevant depending on the circumstances.
Okay.
I think also the Health Act 2006 applies in the health setting in terms of requiring vaccinations for frontline NHS staff. There's a general, encouragement. It's not mandatory, but they're pretty much required to have the vaccinations for the main contagious diseases that they might acquire in the healthcare setting. You can see this falling within that. Again, well, my point is the evidence, because I can't always come back to the evidence and individual prosecutions, but certainly you can see that happening in the immediate healthcare setting where the viral overload is so huge, and perhaps the laboratory setting where people are actually handling the virus.
Thank you. Another question: if you implemented a policy and the staff member took a reaction to the vaccine, who would be liable? I think the first thing I should say is that the three of us on the call are not personal injury lawyers, but I think between the three of us, we know enough to give an educated answer to that. As Ruth has already said, it's really a matter between the employee and the doctor. The doctor or the vaccinator has to obtain informed consent from the employee, from the patient, before giving the vaccine. So if there's an adverse reaction, I cannot see any circumstances in which the employer is going to be held liable unless the employer is actually in the vaccination centre holding the employee down while he's vaccinated, in which case, as Ruth has said, it would be a form of assault and battery. So I'm sure that's not going to happen. But if it's just unfortunate that an employee who has been properly consented by the vaccinator suffers an adverse reaction, that's unfortunate, but I really can't see any liability pertaining to the employer. Do both of you agree with that?
Yeah. I think the question is whether there would be a claim against the vaccine company. I know they've got general indemnity by the government, but Consumer Protection Act claims, which would be the basis of a product liability claim against the vaccine company, are still permitted.
Okay. One of the other questions is, what is the position going to be if local authorities or service users only allow staff into their properties who've been vaccinated? Andrea, would you like to deal with that one?
Yes, certainly. I think I alluded to this in my answer to the last question. That I think potentially could amount to an SOSR reason that would justify an employer dismissing and re-engaging if necessary to put a condition into contracts requiring vaccination. I think you would have to look at it very closely in the circumstances of the case. You'd need to look at how many people were involved. For example, was there any alternative to following this course of action, that you'd engage with a local authority to say, really, is this necessary? Is it justified by the evidence? So I think potentially it could be an SOS reason, but really you would need to look at it very, very carefully in those particular circumstances.
What do we think about vaccine passports? Obviously, it's been a very hot topic in the last few days. I'm intrigued as to what you both think as to whether or not vaccine passports are ever going to see the light of day.
You, Andrea?
I think it has actually been in the press today, Chris, and I haven't, because I've been busy, looked at it that carefully. Well, the government has, up to now, obviously been reluctant. I think they're coming under a lot of pressure, and I think that by default almost they may be forced down that road, because potentially private sector organisations, for example, airlines, travel companies, restaurants, pubs, may sort of try and implement their own system, otherwise requiring people to prove that they've been vaccinated. So I can see that we might get to a position where the government is almost forced down that road.
Okay. I mean, as you say, it's a very recent topic, but my view, perhaps somewhat cynically, is if people are told in order to go to pubs, restaurants, theatres, sporting events, or to engage in foreign travel, you need to demonstrate you've been vaccinated, I think that would increase the uptake. Because obviously I genuinely understand that some people are hesitant. Some people will not be persuaded because they are very anxious. Some people will genuinely have needle phobias. But I think in terms of encouraging an even greater uptake, I think if it was made conditional in some way, I think I can see that happening as a political move. But anyway, we will see. It's never been the case in the UK that jabs are mandatory. So presumably that won't happen again now. All right.
Can I just add, just to be contrary, I think it would be a very big leap to have a vaccine passport. I come from a privacy aspect, and I know Liberty, the human rights organisation, they are all over this. They won't be standing for this. Big Brother doesn't like it. You know, I'm interested in all aspects of privacy online and facial recognition technology and stuff like that. And to require people to reveal medical information just to go into the pub, that's a huge step. And I think the government, you know, you've got a consumer choice. If the pub won't let you in without revealing whether or not you've got the vaccine, you can go to another pub. It's a different thing for the government to introduce that.
Well, watch this space, I think, is the answer to that, isn't it, really? One of the other questions is, a care home in our area have advised that staff refusing to have the vaccine will result in the capability procedure being invoked, as they're unable to carry out their role, which may lead to dismissal, as they feel that staff need to have the vaccine to meet the legal requirements. Is this correct? Is this legal, is the question, right? I think this is a variation of one of the earlier questions. And I think, Andrea, that raises some very interesting and rather convoluted points, because of course the difficulty there is not as between the employer and the employer, but it's in relation to the third party to whom the service is being provided. So if you'd like to comment on that as a employment conundrum.
Yeah, certainly. In some ways, it's quite similar to the question about people refusing to leave unvaccinated employees into their home. So it's a question of third-party pressure. I think the care home in question is probably misinformed as to what their obligations are. You know, as Ruth discussed as part of her talk, there is no legal requirement on the care home in question insisting that all their staff or anybody who has any dealings with them are vaccinated. There may be other considerations. For example, they may be coming under pressure from families, etc., as I said earlier. In relation to any company who's contracting with that care home, for example, to provide staff to that care home, the insistence of a client that they should only provide vaccinated staff may be a factor in how they deal with it, and whether they try and introduce any type of mandatory policy in respect of their own staff. But I think, you know, you would have to look at that very carefully in terms of how important is that client to you? Are they the only people you work for? Can you place the staff in question somewhere else? Can you persuade the care home that they're wrong and they shouldn't really be following that policy. So I think there will be a whole raft of issues you'd have to look at before you said, well, to your own staff, well, we're going to have to make this mandatory because one of our clients is insisting on it.
Yeah, I absolutely agree. Well, I think that brings us very neatly to the end of this webinar then. So thank you all very much for your participation. We were very pleased to see so many people join us on this webinar. We hope you found it helpful. We'll certainly send you a follow-up email within the next few days so you can give us any feedback. And we'll also follow up in a few days with a recording of this presentation in the hope that it was of interest and in case you want to transfer it to any of your colleagues. Thank you very much for joining us. We, of course, are regularly presenting webinars. And if you check out our social media or on our website, you can see the next installments in this interesting saga. So stay safe, stay healthy, and thank you very much for participating.